In overworked public defender news, the Oregon Supreme Court has sided with public defenders who objected to taking cases because their workload was so high. So, yes, it is true that in many places, public defenders' offices are somewhat underfunded, somewhat notoriously. Finding the ability to find funds for prosecutors' offices, people find the ability to find that, but less happy to give money to the public defenders and say, well, you can do more with less because you're defending the criminals, which doesn't make any sense because, of course, everyone's entitled to a lawyer and an effective one at that. So this office was so burdened with work that said we can't do anything more, and then was required to take more in a way that they themselves said led to a deprivation of effective assistance of counsel. And the Oregon Supreme Court has sided with the public defender's office, who said, yeah, we can't take on any more work because of how much a burden this is. So let's learn a little bit more about what's going on in this case. In a preliminary ruling, the Oregon Supreme Court found that a state judge erred by forcing a public defender to take on a new client over the objections of the lawyer's employer, which in this case, of course, would be the public defender's office. So the public defender's office is like, we can't do anything more. We can't take more cases. And it's like, no, you're going to take a more case. And it's like, but we really can't. So we fought the issue and said, yeah, we can't do it. The court ruled that the judge order assigning a new case to a public defender in Marion County, who said that they couldn't ethically represent the client, must be vacated, or the judge has to explain their decision. Oregon's public defender system is somewhat in turmoil. Unfortunately, not necessarily uniquely so. Public defender's offices are somewhat notoriously underfunded, understaffed, with too much work, and not enough time. A lot of dedicated officials there. Sometimes public defenders can be really, really, really good. Sometimes better than their private law counterparts. But it is true that often they are overworked and underpaid for what they do. For more than a year, Oregon has failed to meet the constitutional requirements to provide an attorney to everyone charged with a crime. That has included hundreds of people in jail and thousands more who are not in custody. Not only has the state violated the rights of defendants, the lack of attorneys has created challenges for prosecutions and crime victims. So I guess if I want to become a public defender in Oregon, then I can do that. So should I sit for the Oregon bar and become a public defender? I don't know. Sounds like I'm going to be abused a lot. Not sure if it's for me. For months, public defenders in Marion County have sought help from courts to reduce caseload. They've argued that attorneys' workloads are so excessive, they're effectively violating their legal and ethical obligations as lawyers. At the same time, they argued they were also violating their clients' constitutional rights to effective legal counsel. But judges in the county kept appointing clients, arguing they have a constitutional obligation to ensure those charged with crimes who cannot afford a lawyer get one, which, yep, it's in the Constitution for sure. During a hearing on April the 10th in Marion County, Shannon Wilson, the executive director for the Public Defender's Office, a nonprofit public defense firm, objected to any new court-appointed clients. I'm notifying the court that we are at caseload and workload capacity, they told the judge. I'm responsible for the ethical violations of these attorneys that I supervise and must take remedial action. So yeah, as a supervising attorney, they are at least partially responsible for the attorneys below them. And it's like, if we can't handle more work, if they can't do any more, them taking on more work as an ethics violation and possibly exposing me. Because of the current caseload, all attorneys in the public defender's office, including myself, are unable to provide constitutionally sufficient representation to new individuals facing criminal charges. But the judge appointed one of the lawyers to a criminal case lawyer. Over the public defender of Marion County's objection, I'm going to appoint Tim Downen to represent you, the judge told the defense. So on May 3rd, the public defender of Marion County made a mandamus petition to the Oregon Supreme Court. It states that, as with all the public defenders in Wilson's office, Downen lacks the capacity to take on more clients. The firm apparently only has 64% of the staff it needs to meet its current caseload. So we're already doing the work of 3 men for every 2 that we have. We're already 50% overburdened. As a result of that, every time a public defender attorney, including Mr. Downen, is required to take on a new case, the court is compelling the attorney to violate their ethical duties by forcing them to expend their limited resources on one client at the expense of another, while neither client receiving the resources and time necessary for a proper constitutionally required defense, according to the mandamus position. The Supreme Court's one-page order says that the judge is commanded to vacate the order, appointing them as counsel for defendant, or in the alternative, show cause, which, should be pretty interesting. The Marion County Circuit Court Trial Court Administrator said in a statement, the court is planning to respond to the Supreme Court's ruling in a couple days. The Marion County Circuit Court takes seriously its constitutional and statutory obligations to ensure that eligible defendants have qualified attorneys to represent them, they said in a statement. Josh Krumholtz, Josh Krumholtz, the attorney representing the public defense,